Hi, Jim Selbach. Just to take a couple of minutes to talk about an issue that I think is important in referrals for automatic stay and discharge injunction violations. And the word today is stop. Stop the madness. Stop sending letters to creditors to warn them that they violated the automatic stay. When they've already been notified, they've already violated the automatic stay. They've already violated our client's rights. Now, I know that this is the practice that's been around for a long time. I did it myself for over 30 years, and it's hard to break old habits. But with our system, and I'm going to show you why our system is what Congress intended, we don't send any kind of warning letters to creditors for a couple of reasons. Number one, the statute doesn't require it. We'll get into that in a minute. Number two, it's ineffective, and it defeats the purpose of filing an automatic stay violation motion. Many times we'll get a referral and a letter was sent, the violation was rectified, and now they want a stay violation motion filed. Too late for that. Technically, yes, the violation occurred, the letter doesn't really undo it, but with our judges, there's no point in filing a motion. So I want to get into that a little bit. The idea of a warning shot, the idea that before you can file a motion, you have to give the creditor some warning. A warning for what, actually? A warning to don't violate the stay again, because they already had notice from the court, and we don't file any kind of motions unless we know that there's been adequate notice to the creditor, and they've had plenty of time to stop sending bills, etc. So, I'm not sure what you're actually going to be warning the creditor of because they've already been notified. I guess you're telling them, you violated the stay, please don't do it again. What do the courts say about this requirement? Judge Gerling wrote a couple of decisions in my cases, and here's what he said. It's not the debtor's responsibility to take action that ensures he receives the protection of the automatic stay. Rather, the creditor bears the burden of seeking relief from the automatic stay before taking post-petition actions. So, Judge Gerling's position is you're not required to give the creditor any kind of notice. It's not the debtor's responsibility to say, hey, you violated the stay, please don't do that again. We had another case, the Turner case, in which the defense that was raised by creditors' counsel was you have to fire a warning shot across our bow before you can file a motion, even though there's no basis for that in the law anywhere. And here's what Judge Gerling said. Such a requirement would place an unreasonable burden on the debtor to forewarn the offending creditor to cease and desist before debtor's counsel could reasonably file a Section 362H motion. So his position, which is followed by a lot of courts, says that's not the responsibility of the debtor and it's not a requirement. Now, if Congress, when they enacted Section 362K, formerly 362H, wanted to put a requirement in the statute that you had to give some warning before you could file a motion, Congress knows how to do that. And there's two different laws where Congress did exactly that. The Fair Credit Reporting Act is where something's wrong on your credit report. And if it's not fixed, then you can bring an action in district court against the credit reporting agency and ask for damages, attorney's fees, etc. But the statute specifically says that before you can file a lawsuit, you have to notify the credit reporting agency and give them an opportunity to fix the credit report before you can sue. Federal Rule of Bankruptcy Procedure 9011, also Civil Procedure 11, where an attorney has done something that is sanctionable, filed maybe a frivolous motion or something like that, before you can file that motion seeking sanctions against that lawyer, the rule specifically says you have to give them the opportunity to withdraw that motion first. You can't just file the motion. So, if Congress wanted to make it a rule that before you could file a stay violation motion, you had to warn the creditor, it certainly knows how to do that, and it didn't. There is no such requirement. Here's a case study. This is a recent case that we just had, and to give you an example of the old method and our method, which we believe is the way Congress intended. So we have a single mother, 2 children. She's a pro bono client. She has a minimum wage job. Before the petition was filed, one of the creditors had an income execution on her wages. She files a Chapter 7. Now, on the day that the petition is filed, the creditor and creditor's attorney, a big collection firm, got electronic notification that she filed on the day of filing. Also on the day of the filing, the debtor's counsel writes a letter to the attorney. Please be advised that my client's filed. Please stop garnishing my client's wages. What does the creditor do? And this is a big mistake that a lot of creditor attorneys make. They simply send a fax off to the sheriff. Please stop the income execution. Wash their hands of it, close the file, and that's done. But that's not the law, which we'll get into in other videos. And of course, something went wrong. The sheriff either didn't get the fax or the sheriff didn't do something. In any event, 44 days later, they're still hitting this poor lady's income, okay, which she desperately needs. So what does counsel do? He writes again to debtor's counsel, hey, it hasn't come off, would you please take care of this? Again, creditor's counsel, same thing, lackadaisical kind of attitude towards these things, sends another fax, doesn't follow up, and what happens? Again, sheriff does nothing, there is no follow-up, and 9 days later, our office is retained because it's obvious that nothing's happening here, and they keep hitting her paycheck. So, the very day that we got this referral, we filed a 362K motion, and we served creditor's attorney. The sheriff waits another 18 days for some reason, and does nothing. And of course, debtors or creditor's counsel isn't following up, so they don't know that the sheriff isn't doing anything. The sheriff doesn't actually get the information to the payroll department for 24 days. And so we got another paycheck that's garnished. This is even while the motion is pending. The court finds a willful violation of the automatic stay. The court directs an immediate refund of the fees. Our office received an overnight package the next day with the refund that the client was entitled to. The motion was finally settled, and here were the terms of the settlement. All post-petition monies were refunded to the debtor. She received $1,500 in damages. There was $7,000 paid in attorney's fees, and debtor's counsel got $1,750. But there was a gap in the beginning where letters were sent, nothing was happening, but once the motion was filed, we got relief from our clients. So please, stop sending letters, stop calling creditors. Although, if you don't want to send us the motion, I mean, I'm not telling anybody what to do here. I'm simply saying you can't mix these two systems. If you don't want to send it to us, sure, try the old method of sending letters, etc. But if you're going to send it, please don't send warning letters.